Right. Raise your glasses, folks. Ladies and gentlemen, this toast goes to Smooth 98.1. We are culture. We are. We are.
Smooth 98.1. Love music, love life. It's 1 minute past 9 o'clock. It's 20th of March, 2025. It's a Thursday, and it's now time for Lagos Talks right here on Smooth Breakfast. My name is Oluwaseun Olusegun. And this morning on Lagos Talks, what Lagos is talking about is will. Will, not as a verb now, but as a noun. And we're talking about that piece, that document. In fact, we need to understand what a will is, what is in or should be in a will. How do you go about writing it? Who should have a will? How do you execute it? And so on. If you have questions, please, you're welcome. WhatsApp line to send your questions to be a part of the conversation, contribution, and for you to seek further clarity is 0809-444-0981. Again, 0809-444-0981. We're also streaming live on YouTube, so you can join us at Smooth 981 FM Lagos. And taking time out of this schedule to be with us and to shed light on this topic, please welcome with me, Mr. C. Good morning again.
Good morning, Oluwaseun. Good morning, Lagos.
Thank you for doing this and being here. So let's start with the fundamentals, the foundation. It's easy for us to think of a will as that document that has all your inheritance, everything you've ever owned, and how you should be it should be shared to the people around you when you're gone. Is that all about a will, or how should a layman understand will?
Okay, thank you, Oluwaseun. So a will, put very simply, is a legal document that expresses a person's wishes regarding the distribution of their property and assets after their death. So let me break it down further. Let's say there's a man called Chief Lagbaja. In the course of his lifetime, he owns about 10 houses, he owns about 20 cars, he has 3 farmlands, and then he has 7 plots of land that he hasn't developed. Now, Chief Lagbaja has a family, he has children, and then before he dies, he then decides, okay, I want to distribute my property to my family in a certain manner. So he could do it himself, or he could consult a legal practitioner. And then the document which then contains the list of all his assets he owns and a clear identification of everybody he intends to give property to is stated. And then beyond stating the properties and the individuals, he then states who gets what. In addition, the will only becomes operational or active once the testator is dead. So while the testator is alive, it does not become operational. Now, the will has to be witnessed by at least 2 witnesses. So, yes, at least 2. So, Chief Lagbaja will list out his property in the documents. He will list out the beneficiaries. The beneficiaries are the people who will receive the gift of his assets. Then he will name and identify the executor and or executors of his will. Now, who are the executors? The executors are the people who have been appointed by Mr. Lagbaja, Chief Lagbaja, during his lifetime to ensure that his wishes are carried out post-death. Now, in addition to property and assets, sometimes cash is left. So he can also indicate who gets what cash. He can also set up a trust, maybe for younger beneficiaries who have not yet reached adulthood, who have not yet turned 18. So In essence, a will is a document that spells out the wishes of the testator as regards the distribution of his property and assets after his death.
I want to fly many miles ahead, even though that should come later on. And it came because of what you said about the two people or the people who should execute and should make sure that this thing is carried out. So how then do you ensure that, is there any provision in the will that really makes sure that these people, because these people are able to fully execute. If I say I want you to give 2 pence to my first child, but something happens and I say Mr. B, who's supposed to help me make sure that 2 pence should be given to my children, my first child. Maybe my great-grandfather from my mother's side comes and says, no, you cannot give 2 pence to the first child. The first child is a female, so the first boy should have it. How does the piece of document derive its power?
Okay, so remember that the will is the document of the owner of the properties. Now, this relative you described is not the owner of any of the properties. He only becomes an owner of any of the properties if it has been given to him and by virtue of the will. So where an executor has clear and precise instructions, he should follow them for as long as they're legal and they're valid and do not contravene any existing laws of the country. But that a relative just comes out from thin air and says, you can't do that. No, the relative isn't the owner of the property, wasn't the owner of the property when the will was made. The relative has no say over how that property is devolved. Now, the reason why I say this is there's a legal maxim that says you cannot give what you don't have. So the executor derives his authority from the will. The relative you've described, where is his authority coming from? There's no authority. None was given to him. So then how he feels, the wishes of the testator as contained in the will be given full effect. And if a lawsuit were to be filed, the court would give full effect to what are the contents of the will. And that in essence means what were the wishes of the testator before he died, not what his extended family believes or understands.
I hear you loud and clear. And with this, I still wonder why people still drag, especially when the will has been left. And you still have people saying, family still stepping in to struggle the properties. And what if it is other person is left behind with the person who it should go to?
So I would say it partly stems from a lack of understanding of how wills work and how they're executed, but also it partly stems from greed. Now, why I say it partly stems from greed is if they're so sure of their rights, of their presumed or believed rights, why didn't they approach the testator when he was alive and demand for the property? Clearly, the testator would have laughed them off. But because he's dead, and more often than not, when the testator dies, the people who are left, surviving family, sometimes tend to be vulnerable. Maybe you have children who are minors, you have a bereaved widow, then they're throwing all sorts of phantom customary traditions and regulations at her. But for a man, and I advise this for every Nigerian man who's married or who intends to get married, protect your family by ensuring that you have a will, which clearly spells out how your property will be disposed of. Because if you don't do that, you leave your family at the mercy of greedy, opportunistic family relatives who will quote all sorts of family traditions, which may or may not be true, and they will take properties they shouldn't have gotten. More importantly, if you cannot do a will, you can gift the property during your lifetime. So rather than wait to death where someone can challenge a will on the ground that you lacked the testamentary capacity to make the will, which is you are not mentally okay when you make the will, give them your lifetime. Then let's see who will challenge that gift.
Thank you. Join the conversation by sending your messages to 0809 444 0981. Is there age factor in will execution? I mean,
You have to, okay,
go
yeah,
on.
you have to be at least 18.
Ah,
Yeah.
so until the child is 18, what happens?
No, so is it with regards to making a will or to receiving?
Receiving.
No, you don't. So if it's with regards to receiving, right, an adult can receive it on behalf of the children, or the executors would probably have been instructed via the will that they should act in a position of trustees towards the children until they turn 18. So they can't take direct benefit until they turn 18. They have to be, once they turn 18, they don't need the assistance of the executors. They can directly receive it, except, of course, the testator has said you take possession of whatever gift from the will when you say turn 21, turn 25, or turn 30. And like I said at the beginning, the testator's wishes will be fully respected.
It feels like I'm listening to you and I'm hearing a lot of loopholes that can be plugged into that receiving on behalf of the person. And what I mean is, in a case where, yes, you can receive it on behalf, or you can manage an estate on behalf of the child before the child is 18 and becomes an adult. And if it is something that is non-renewable, how do you ensure that this thing does not finish before it gets to the child?
No, when you say non-renewable, what do you mean?
I mean something that has a limited supply.
Okay,
for instance, if it were to be a certain amount of money, not landed property now, I suppose money can be willed, right?
Yeah, you can give money under a will, correct?
So if it were to be money, so let's say Mr. A willed 100 million naira to baby B, who is 7 years old. It's going to take 11 years old before baby B is 18 years. And on behalf of baby B, the uncle of baby B needs to be the one that is receiving on the behalf. What's going to happen to that money? They keep it in the safe, the trust fund, or Uncle B can be spending on behalf?
So because baby B is 7, the testator should have made arrangements for the money to be kept in an interest yielding account until baby B turns 18. Now, even if that is done explicitly, all executors have a fiduciary duty of trust towards the beneficiaries of the will, meaning that at all times they must act in utmost good faith towards the beneficiaries and have their best interests at heart. So what does that mean? I'm a trustee of a will. The testator did not make express provisions for an interest yielding account. The beneficiary is 5 or 7, and it's 100 million. The best way to safeguard that money is to put it into an interest yielding account, properly identified, and it will have 2 names on it. It will have my name and the beneficiary's name as co-account owners. When the child turns 18, I'm then taking off, and the money plus whatever interest that has accrued over time goes straight to baby B. So where a trustee fails to act properly with regards to his duties towards the beneficiaries, his actions can be challenged in court. He can be compelled by an order of court to render an account, and where there's any shortfall, he can also be ordered by the same court to make that shortfall good towards the beneficiaries.
It makes a whole lot of sense why it's called trustee, meaning there has to be that level of trust in this individual that you're going to say, you should do this. Otherwise, a lot of things can go wrong. It makes sense.
Agreed.
Thank you. Now we continue with the conversation, but we'll take a breather. And when we come back, I want to know if there are other things that makes a will invalid. How do you save or store a will? And so on. You're listening to Lagos Talks right here on Smooth 98.1. So why do we, I'm certain I'll ask that question on air at some point. Going by your level, I mean, your experience, what's our attitude to will writing? I mean, I can already tell that Nigerians don't like to write will.
Correct. So they have a superstitious approach or understanding of wills, because they're like, when you tell someone write your will, traditionally the person will then respond, are you expecting me to die soon, or do you want me to die? But we should move away from that perspective. It's like your will is like a spare tire in your car, in the trunk of your car. Now, because we have spare tires, we don't wake up every morning praying to have to use them. But it is good to know that it's there and you use it. It's also like insurance. Take out life insurance. People say, no, are you expecting me to die?
I need you to say this thing on air when we come back, and then we go into what can make a will invalid and other things.
Okay. Okay.
So on Smooth 98.1, that's a combination of radio and coffee.
You're listening to Lagos Talks right here on Smooth 98.1. It is now 18 minutes past 9 o'clock. And this morning we are talking about will writing and execution. I do have Mr. C with us. And in case you've forgotten, Mr. C is a legal practitioner. And this morning he's dissecting the matter of will writing and execution. And you can join us on YouTube at Smooth 981 FM Lagos. You can also send a message with any questions or anything you'd like to say to 0809-444-0981. You can dial 0201-448-9981. Behind the scenes on YouTube, I was asking earlier why Nigerians seem to have that aversion for will writing. And Mr. C was saying something. Would you like to say it on air?
Yeah, sure. Okay, so traditionally, the perspective towards wills by some Nigerians, at the very least, hasn't been very good or appreciative. Now, the reasoning is simple. For some reason, traditionally, we've equated having a will with accepting impending or coming death. So people, as an affirmation of life, refuse to have wills, saying that, oh, they're not going to die any soon, that they're going to put their affairs in order before they die, and that they tell you stories of people who have lived long in their families down the generations. But we can also liken it to the approach they have towards taking out insurance, especially life insurance. It's the same approach that, oh, we're not going to die, there's nothing wrong with us, why do we have to take out life insurance? Are you praying death upon us? Are you saying we're going to die soon? But I liken wills to having a spare tire in your car. Now, having a spare tire in your car doesn't mean that every day you set out to drive, you are deliberately hoping and praying you get to use a spare tire. No, but it's good to know that it is there so that in the event it becomes necessary to have a will, it's a lot easier. Now, there have been prominent families where the breadwinner dies, there's no will, and there's all sorts of confusion. Different factions are fighting, especially if it's a polygamous setting, they're fighting themselves. And even if it's a monogamous setting, different people are saying, I should be entitled to this, I should be entitled to that. And it's extremely messy, especially when it gets to the court. A will is simple and straightforward. It clearly identifies who gets what.
Mm.
Now, that doesn't mean wills cannot be challenged in court. That doesn't mean wills cannot be said to be either flawed or should not be accepted. Now, when a testator dies, the executors then take a copy of the will and approach the probate registry of the High Court. And they file an application stating that the testator of the named testator of the will is dead. They attach his death certificate, attach the will, and apply for grant of letters of administration. Now, if the High Court's probate division is satisfied with the application, it will grant probate of the will. And it is at that point the executors can then begin the distribution of the property and assets. The property and asset distribution can only start after probate has been granted. So it's not automatic that Mr. Chief Lagbaja dies on Monday, they start sharing the property Tuesday. No, it doesn't work that way. Because the High Court also has to do an assessment of the value of the property and assets, and a fee is paid based on that assessment. So the probate registry will do an assessment which you pay into the treasury of the High Court. And once that is done, you're then granted probate, and then you can then start your work as an executor.
That is interesting. I didn't know it involved all that process. Now,
Yeah.
speaking of process, for the sake of someone who's probably just tuning in or someone who wants more clarity, let's go back. Now, somebody has heard what you said about you need to protect the ones who you are leaving behind. Anything can happen, right? So if you want to start with writing your will, what should you do? What are the steps you should take when you want to write your will?
Okay, so before you start contemplating writing a will, you have to properly and carefully itemize all the property and assets you want to be covered by the will. Now, it is possible that you can have 10 houses, you want only 6 in the will, you will gift off the remaining 4 or you'll sell the other 4. So whatever property or assets you want in the will, what you want covered by the will, you have to properly identify it. Now, once that is done and you've carefully identified your cash balances, I always recommend see a legal practitioner. The legal practitioner will put it together because he's experienced, he's trained. Yes, you could say that as a layman, you have a pretty fair idea, but in order to avoid any complications further down the road, give it to a legal practitioner. He will then what to do where beneficiaries are much younger. He will suggest the setup of trust. He can then suggest how to dispose of the property in what manner. And if for any reason you have failed to cater for someone who should be covered, the lawyer will advise you. So for example, if you have children less than 18, well, maybe because you had a quarrel with their mother, you say you're not going to put them in the will, you're not going to provide for the wife. When that will is presented to the High Court, and the High Court establishes, in fact, there is a surviving spouse, there are surviving children, they're not yet 18, the High Court can then make incidental orders mandating that they be looked after through that will, even though they were not initially named. Now, the reason for that is on grounds of public policy. You cannot willfully abandon people you're supposed to be looking after merely because you have passed on to the others.
That's interesting. Now, if a person wants to update their will, do you go through the same process, or you can just simply call a lawyer and say, put in this person?
So if you want to update your will, you have to have a copy of the old will. So let me explain this way. You can make a will in 2022. In 2023 and 2024, you've acquired more property, which are not covered by the 2022 will. Now in 2025, you have one of two options. You can do a fresh will in which you will revoke the other will and then incorporate all the property and assets you have as at 2025, or you can do an amendment called a codicil and say that in addition to this existing will, these assets, this property now join that will, and both documents should be read together instead of independently or separately. But again, I
Okay.
advise give it to a legal practitioner.
Okay. So you cannot just on your own have two witnesses, like you said, get a sheet of paper, write what you have, and say this was done in the presence of this.
Okay, so here's the thing, right? So let me talk about the contents of the will, so that we can then see why it's always advisable to use a legal practitioner. So the contents of the will, first thing, it must identify the testator. So what does that mean? The testator's full name, address, and date. Then a revocation clause. In case there are any previous wills, that clause will then revoke all previous wills and make the present will the enforceable one. Then appointment of executors. And like I said earlier, these are the people who will administer the estate once probate has been granted in respect of the will. Then have the beneficiaries, and these are people or entities who will inherit the assets. Now, the will must also speak to distribution of assets. And then for minor children, yes, I didn't add this at the beginning. There must be provision for the appointment of guardians for the children, especially with regards to the receipt of gifts, until they come to a legal age where they can administer those gifts independently and lawfully. Then fine. And finally, a residuary clause that disposes of any assets not specifically mentioned in the will. Now, if you were to do this as a layman, you may not have a residuary clause. So if for any reason there's property that has escaped your mind, your attention, or your memory, it might prove a bit of a problem once you're gone, but a lawyer will capture that. A lawyer will also that you have to appoint guards for minor children who are minors, and that you can't just give them and take receipt immediately.
I see why you cannot afford to have a falling out, even though they are meant to be professional. They always should be professional, but you cannot afford to have a falling out with your doctor and your lawyer because they know the entire thing about you. Oh, interesting. And on the final note, before I let you go, what makes a will invalid? Because earlier, when you were talking about how a will could be challenged in court or something like that. So what makes a will invalid?
Okay, to answer your question, to answer your question, one, a lack of testamentary capacity. Now, what does that mean? For a will to be valid, this testator, as at the time of writing the will, must be of sound mental capacity. Now, why is this important? If it can be shown that as at the time the will was prepared and signed, the testator was not mentally okay, then the court cannot give effect to any purported document arising out of that mental situation. Now, I must say this clearly. That person can validly make a will, but there's a caveat. If it can be proven and firmly established that as at the time that will was made, he was lucid enough to understand what he was doing or what was being done on his behalf, because it's either he's doing it directly or the lawyer is preparing it for him and he understands what the lawyer is doing and he can confirm that what the lawyer has done perfectly aligns with what he wishes should be done. So one, if you cannot prove the testator was of sound mind, then the will be invalid. Now, if you can prove undue influence, so for example, you can show that a particular relative or a particular child leaned on the testator heavily to skew the distribution of the property and assets in his or her favor, then as it pertains to that allocation, it can be set aside. But then you need to lead a lot of evidence. You need to be, if you prove undue influence, you should be prepared to lead evidence to support the claim. Now, fraud. If you deceive a testator into making a will, and that fraud can be clearly established, the will be invalidated. Because nothing can come out of fraud. Nothing lawful, nothing valid can come of a fraudulent exercise. Then improper execution. So the testator doesn't have a proper signature, insufficient number of witnesses. I had said earlier that you need a minimum of 2. So let's say only one witness indicates clearly states that he witnessed the preparation of the document and he witnessed the testator saying the will be invalidated. Then the witnesses not signing in the presence of each other. Now this is very key because we like to cut corners a lot. If the witnesses do not sign in each other's presence and it can be clearly established the will be invalidated, then lack of an attestation clause. This clause merely states that the will was properly witnessed. Now, if there's a subsequent revocation, any previous will goes out of the window. So if I'm challenging the will of Mr. Lagbaja and I can prove that there has been a revocation or a subsequent will, then the will being challenged will be invalidated. Then finally we have forgery, we have ambiguity. So if I can prove that the testator's signature is a forgery and is not the signature of the testator, the will be invalidated. Then illegality, if any part of the will directs an illegal act to be done after the testator's death, that portion of the will be invalidated.
Thank you, Mr. C. I must let you go now, but I'm really grateful for this time that you've taken out to give us this detailed understanding of will writing and execution. And I hope that somebody finds this instructional, that you write your will. It's not you signing your death warrant. It's you just doing the needful like you'd have an insurance. So please do not let your heart palpitate whenever you need to think about writing will. And of course, if you're going to have trustees, this is my advice now. Make sure that you trust your trustees. And yeah, it's important. Thank you so much. You can find this video on YouTube. Go back to it and watch it, and you need to share it with someone you think needs this information for them to take the required steps. Thank you, Mr. C. I hope you have a lovely morning.
Thank you for having me. Bye-bye.
Bye. All right, that's Lagos Talks for this 20th of March 2025. And tomorrow we'll return for a Lagos Talks, but that time it will be Feel Good Friday. And it's going to be something light, fun, but of course it will be something that gets us talking right here on Smooth Breakfast on Smooth 98.1. My name is Oluwaseun Olusegun, and the music will be with you because we continue Smooth Breakfast.
Music. This is Mr. C, and you're listening to Smooth 98.1.
Yep, Mr. C. Thank you for joining the stream.
Upon us. You have till March 31st to file your returns. You can do it anywhere. Office, traffic,